Rambam,
Shalom, everybody.
we're learning the laws in Maimonides' teachings about agents and partnership. We're going to do chapter 3 today. What does it mean someone to act as your agent in a business deal or whatever the case may be? Okay, so we're going to do the second chapter of today, which is chapter 3. Chapter 3. The following laws apply when a person owns landed property that another person is using, or he has a movable property that he had given him as an entrusted object, and he seeks to appoint an agent to carry out legal procedures with that other person and expropriate that property or entrusted object from his possession. He must compose a deed granting him power of attorney. So I have a piece of land, right? Sorry, guys. I have a piece of land, right? And this piece of land that I own is in Yankel's possession, right? He's using it. I rent it to him, whatever, right? Leased it to him, whatever the case may be, right? Or, I gave you my phone to hold for me while I was away, right? For example, a movable piece of, right? Now I want to appoint an agent to carry out a legal procedure, right, with the person who I, let's say lent the land to work the land, right, for example. Or an entrusted object to get it from his possession. So I have to make a legal document giving the power of attorney to the agent. He must perform a kinyan, certifying that he was granted power of attorney, telling him, take it to court, acquire it, expropriate it for yourself or the like. One second. So I have a piece of property, but I'm having a difficulty with the person who I lent it to. So I want to go to court, right? But I'm sending my agent to go to court instead of me. I have to write a legal document to make a kinyan, an active acquisition, giving that person power of attorney, right? Otherwise, if that agent comes without being a document and an active acquisition, the person who I've had contention with, right, he'll just say, I don't have anything to do with you. I have nothing to do with you. You can only act in the stead of the person, the agent, in this kind of instance, when he's given the power of attorney. Okay? We have that similar today, right? Now, if me being the principal, I don't compose such a deed for the agent, he may not enter litigation on my behalf. For the defendant will argue, you are not a party with whom I have contention. Even if the principal does not compose such a deed, the agent is no more than that, and any property that he acquires belongs to the principal. And any expenses undertaken by the agent with regard to the dispute for which he was given power of attorney must be borne by the principal. But this is also written in the deed granted power of attorney. All expenses will be undertaken. In this case, I undertake to pay. Right. Okay. Halacha number 2. If the principal transfers ownership to the person to whom he gave a power of attorney, granting only a third or a fourth of the property his colleague is holding, the person granted power of attorney may enter into litigation concerning the entire holding. So let's say I have a field and I'm going to court with somebody who I lent it to and he's not giving it back to me, right? So if the person who I'm making my giving them power of attorney, let's say I gave them part of the property, a third of it, right? I granted him a third of the property. Maybe that's my payment for him. Let's say, whatever. It doesn't matter for what reason, right? יונתן, מחר, הערב, 7:30, כן? מעריב,
ב7:30?
7:30.
ומה עם מנחה?
אולי ב2, לא יודע.
אוקיי, בסדר, בלי נדר.
7:30.
אוקיי,
תודה.
כל ז'ורנה.
Bye bye. So the fact that he has a part of the land, right, that I granted him, yet he can enter for the litigation on my behalf for the entirety of the land. Okay? Since he is entitled to enter litigation concerning the portion that he owns, he is justified to enter into litigation with him on that. He may enter litigation concerning the entire amount. Okay. In this instance over here, he did not write a document for power of attorney. But I gave him some of my land. I gave him a quarter of the land, third of the land, whatever, right? Now that he could go to litigation against this person, he can go to litigation not just for his part of the land, but also for my part of the land without the documentation. That's the point over here. Okay? Got it? Very,
Got it.
excuse me, very detailed. Halacha number 3. When one of the group of the brothers who have not divided an estate between themselves, or one of the group of the partners comes and lodges a claim on a portion of the property they assert to be their own, his claim involves the entire property. The defendant must respond to him. Since this person owns a portion of the property in question, he does not need the power of attorney from the other partners because he owns a part of it, so he doesn't need power of attorney. If the defense prevails, another one of the partners cannot lodge a claim if the defense prevails, another part of the portion partners cannot lodge a claim against the partner who engaged in litigation, telling him, if I had been there, I would have raised other arguments and caused the defendant held liable. But the partner who engaged in litigation can tell him, why didn't you come and raise those arguments? For this reason, if the other partner was in another country, the partner can seek out the defendant and enter litigation against him, telling him, I do not agree with the arguments my partner raised. That's if you were out of town. Accordingly, the defendant can delay, telling the first partner, either enter into litigation concerning only your share, or bring me power of attorney from the other party, or I am holding property. For I'm holding property belonging to both of you, and you both are involved parties in this case. Tomorrow, your brother or your partner will come and lodge a claim against me. Okay, we're gonna have to stop here.